you Beanie Segal.
What do you want to call me?
There's a big time rapper. His name is Beanie Segal.
Oh.
I love when people say Lis Pendens. Oh, I'm sure you've heard people slaughter the word.
Uh-huh. All those Latin words, right? Why do we even still use them?
I don't know. Let's go follow.
I had to learn all those in law school.
Oh, you did?
Yeah, there's a Catholic high school up here. They're still required to learn Latin.
What?
Yeah, it's one of their classes.
I guess I could give the Baron's definition. I don't even know if it's in the book or not. I know
Yeah.
it's a lawsuit pending, but
I think it means to give notice.
Liz. And why isn't it Lis? Here it is. All right, we'll go over that. I'll start with that. We're live now.
Okay, sounds good.
Roundup family. Hey, Roundup family. Daniel, Bobby. Daniel, I got your message. Yeah, when I get a time to slow down, I'll hit you back, my brother. Roundup family, welcome to Attorney Time with Jessica.
Hello. Hey, everybody. Friday. Yeah.
I don't like Fridays. I don't like them because business doesn't go over on Saturday.
Wow, that's actually impressive that you take a day off. I thought just business was all week long.
No, not for me. I'm talking about out in the world. Business kind of, loans don't get processed, title companies close, the banks.
I see what you're saying. Yeah, we never stop working.
Yeah, you never stop.
Yeah.
Roundup family, greetings. This is Chris Haskins again with Jessica Segal at Attorney Time. Today we're having I live like a few miles from the Langley Air Force Base. They got these jets flying around. I'm going to do a video, Jessica. You're going to love it.
Okay.
These videos.
That's awesome.
Anyway, so you might hear it. Roundup family, today, my mission, my ministry is to raise your financial literacy through real estate investing and entrepreneurship. In doing that, I get the humble opportunity to hang out with Jessica, who is an attorney in New York. Good afternoon, Jessica.
Hey, good afternoon. Happy to be here. Got an interesting topic today.
Yeah, me and Jessica have been going back and forth.
Yeah, it's good. I love it when we have like a real case to talk about. I think it's so helpful.
Yeah. So the reason we were talking about this was mainly to assist you in preventing your seller from, I don't like calling backing him out of your signed contract, but I mean, that's the only way I can say it. Is there any other way to say that?
Yeah, I mean, breaching the contract is the legal term, but yeah, how do you stop them from taking advantage or breaching that agreement that they signed with you?
Nice.
And I think that the more you do deals, the more it's going to happen. So this will be a good conversation to have. Like, what do you do to prevent it from happening, or what can I do if it does happen?
Gotcha. Hold on, Jay. Let me check something. I think something's going on with the YouTube. This is weird. Well, yeah, we're good to go.
Okay.
Hit it. Let's do it. Well, what would we want to do? I want to kind of give us when would we want to use one as opposed to the other. Then we'll go down the little bullets on how they would work best.
Okay, great.
Situation. Memorandum.
So that's basically a document that you're going to file with the contract in the county clerk. And it's basically putting people on notice that you've entered into a contract to purchase or sell this property. So it comes up as a red flag if anybody does a title search that the property is under contract. And it's very inexpensive. It's a couple of bucks. You basically file it with the court. And I had a case where it really helped. A seller entered into a contract with my client, and she was excited about the deal because it was going to be a profitable flip. And the couple was going through a divorce and decided, we're not 100% sure. Either they decided they're not selling it, or they got a higher offer from somebody else. But we know they wanted out of the contract, and they tried to just offer to give back the deposit. But my client said, that's not good enough. I want this house, and you entered into agreement, and I was going to profit from it. And so I don't want just my deposit back. I want the profit I would have made. And so it got ugly pretty quick. And so the conversation I had for her, we're going to get into this for the Lis Pendens too, is the conversation turned to, well, how much money do you want to spend on my attorney's fees litigating this contract dispute, breach of contract, because they are in a position where they don't want to sell the house anymore. And it was very frustrating. The good news is the only reason she found out about it is because somebody else was trying to buy the property.
Another buyer.
Another buyer who saw that memorandum filed and called the attorney that prepared the memorandum of contract. So wow. I give a lot of credit to that attorney that filed the memorandum of contract, because a lot of attorneys don't do that.
They keep it in the file.
They just keep it in the file. I thought that was really smart. And I think the seller thought she would never find out. Probably. And he was just going to sell it out from under her. So I'll tell you, that was months ago, and it's still in limbo.
Really?
And she's trying to figure out what she wants to do, how far she wants to take it. But he can't sell the property to anybody else until they work this out. So she's won that part of the battle. Now the question is, what's the remedy? If I either let the seller out of the contract, or I take it to court to force the sale of the house. Okay. No. So yeah. No, so it's one of those, it's a great tool. It's, just a few dollars to protect yourself from a seller who's going to try and work that deal to somebody else.
So does this document, Jessica, require signatures on both sides?
Yeah, so the memorandum of contract, you need the buyer and the seller to sign it.
This is important, class. Make sure you take note of this. That's why I want to do the verses, so you can see which one is which.
Yeah. Now, as a buyer, we always make sure there's contingencies for us to get out in our contract, right? If there's mold, if there's termites, if we can't get financing, whatever. There's always a list of contingencies we put in there. If you're lucky, you get away with, for any reason we want, to back out of the deal. Some people will do. But we never really talk about the seller's contingency. So if, in this particular contract, there were none. So the seller's really in no position to argue. But if, as a seller, you can always put in a contingency that says, subject to things like divorce or bankruptcy or some other failing to get my job, or like in this particular case, let's say somebody's selling their house because they got a job out of state. You would want to put in there a contingency that the job actually comes through. Most people don't want to sell their house if they don't have to move. So that's the question is, okay, how far are you going to push it? If somebody entered into this deal with you because they thought they're moving, and they gave you as the buyer a great deal because they need to leave fast, and now they don't have to leave. Are you going to still force them to move their family because you want your deal? Right?
Yeah.
So that's when we start looking at, I guess, the integrity of our business.
Yeah. This is where Jessica and I we're kind of talking about. We don't want to sock it to them too hard. It on each situation has to be handled differently.
Right, right. Like, look, in this particular case with my client, she was really angry because we kind of think that they were just trying to get more money for the house from somebody else. Okay. So that's not right. That's unethical. You can't do that. You entered into this agreement. So I agree. If you wanna go after them for the breach of contract, you'd win, right? But if it's like this, somebody thought, hey, listen, we're moving because I got a job and now that job isn't coming through. Are you really going to force this family out of their house, or are you going to maybe just work out some sort of financial penalty for not going through on the contract? Every situation is different.
Mhm. Before, just say for instance, so we're this memorandum, we're getting it signed at the time of contract ratification on both sides.
Yes. So, right. So the seller's attorney or whoever it is, seller usually sends you the contract, or if you're doing your purchase and you're creating the purchase and sale document, you sign it. When you send it to them, the seller, they sign it, or, vice versa. You make sure you're both signing off on it, and then you file it in the county clerk's office where the property's located.
Gotcha. Now, Jess, when I'm filing mine, I am blotting out or darkening out the price and the date on there. I didn't tell you this, but is that something that you recommend or don't recommend? Because I'm filing the
Um,
memorandum and then I'm attaching the contract to it. Would you
Yeah, I
recommend
wouldn't block out the date, honestly, because I think that's connected to the contract.
so saying just to
But I don't think the price is an important thing. I mean, that's not part, yeah, I don't think it doesn't negate the memorandum of contract if you block out the price.
I got you. Okay. Okay. Just just trying to
Yeah,
always trying to protect the anonymity. Okay.
yes.
All right. So that is your memorandum. The key thing here you got to remember is need signatures from buyer and seller, which is so crucial.
Now, I'm gonna ask you a question, given your land trust video.
hmm
If you're buying this property in a land trust, when you enter into the purchase and sale agreement that you're now going to file a memorandum of contract on,
Yep.
who are you listing as the buyer? Because your land trust isn't created until closing table.
That's right. Well, I am not creating the trust until we get closer to closing, but I know what the name of my trust is when I'm drafting
Okay.
that purchase and sale agreement.
Okay. So you use what you expect to be the trust name as the
Yeah,
buyer? Okay.
absolutely.
That's what I figured, and that's what I would recommend. But I wasn't sure how you did it.
So the thing is that when you go record it, they're going to put it under the trust, and then still you got my trustee is going to sign the memorandum down at the bottom anyway.
Right. Right. Right.
Okay, Liz. Memorandum. I think we talk about this candidly, Jay.
Yeah.
It took me 4 years to figure this out, and I had to
Yeah.
actually create my own memorandum because I asked a million attorneys. I'm like, I remember going from attorney to attorney to attorney to attorney. How can I prevent sellers from backing out of my contract after they signed it? You know, and it was almost generally accepted. Like you can't. They're telling me like sometimes some people get buyer's remorse or seller's remorse, and they just want to get
Mhm.
out of it. And I'm like,
Right.
there's got to be a way. Then I found this attorney in Georgia. He gave me little pieces. So class, I know this sounds like Jay and I just going back and forth with this, but this right here could be the difference between you making 100 grand or making nothing.
Absolutely. And you know what? This is those little bits of advice from hands-on experience. Like we're out dealing with this stuff. Like you're living it, I'm living it. And
Mhm.
so if we can pass that on, it's so helpful. I mean, now that and I'll be the first to admit, I mean, I wasn't aware of all this stuff a few years ago myself.
Wow.
So now that I've learned about it, I help protect my clients by suggesting that they do these kind of documents.
Wow, that's cool, Jay.
Right. Oh yeah, it's really and the ramifications to not doing it are huge because especially if it gives you bargaining power, because even if you agree, you know what, I'm not going to push it, okay, we're going to walk away from this contract, but you owe me, right? Because I would have won a breach of contract if we went into court. So what are you going to give me if I let you out of this contract?
Mm-hmm.
So it's always going to give you the upper hand.
And even if my thing is this, and before we get to the Lis Pendens, Jay, they file it. Say they do want to sell it to somebody else. I'm like, you know what? It's not at the end of the world. All you have to do is pay me. We have to file something called a release of memorandum.
Yes.
And
what are you going to pay me for that? Right. Right. And so the that person in the position of being the ultimate buyer is going to turn around and maybe pay you for that release.
You got to have a conversation with this boy. That's all I want. Talk.
And that's what the document does. It forces that conversation.
Okay, Lis Pendens. You want me to read the thing here, or you want to just go for it?
You go. You can do it. It basically means to put you on notice. But what is the textbook definition?
Baron Real Estate. Get your book, Roundup family. This is Latin for a suit pending, recorded notice of the filing of a suit, the outcome of which may affect title to a certain piece of land.
Right.
That's it.
So
same thing.
This is a really very similar concept to the memorandum, but this requires that you attach the document to it's more of a complaint or an action, and you're putting people on notice that the title to this property is in question. And the key difference is that you have some sort of interest in the property, and that there would be a valid lawsuit attached to it. So again, very similar to the memorandum. The key difference is you only need the plaintiff or the person who would bring the lawsuit as the only person required to sign off on the Lis Pendens.
The plaintiff.
You don't.
Go say that again, Jay.
So the plaintiff is the only required signature on the Lis Pendens.
And so for real estate people, that's be the file.
Well, whoever the aggrieved party is, whoever thinks that their contract is being breached, because it could go either way. Typically, it's going to be the buyer, but not always.
I'm going to put plaintiff / buyer, because we're protecting our buyers. Is that one F or two Fs, Jay? I don't remember.
Two Fs.
Oh, plaintiff.
Right. So if we're acting under the assumption that I'm the buyer, and this deal is not going through, and somebody's breaching the contract that we entered into, then you're going to be the plaintiff, and you're bringing an action for a breach of contract. But for example, like the partition action that we've been, talking about, the depositions that I did and things like that, when the complaint was filed for the partition action, which is the forced sale of a property when you don't agree on how to sell it for joint owners, we filed the Lis Pendens with that, putting people on notice that this property is the subject of a lawsuit. So it flags it for anybody who thinks they're going to walk in and buy that property or has a judgment against the property or something like that. It's a very, very powerful tool that is underutilized. And the attorney that I was working with, I do some trial counsel work for other attorneys. Very smart attorney. He used this document. A lot of attorneys around here don't use it. So when he filed the partition action, he filed the Lis Pendens with it. So when in the course of that partition action, the defendant tried to alter the lot line of the property in the town, it was actually in violation of the Lis Pendens that was filed. So she could have been held in contempt of the court.
Wow.
There could have been sanctions against her personally. So
did they try to hire a land surveyor to move the line?
She applied to the town to get the lot line adjusted
Wow.
so that the property would be bigger, which would get more money when it was sold.
Gotcha.
But you need consent of both owners for that.
Yeah.
And the other owner didn't consent. And she forged his signature. I mean, there was all kinds of stuff in that. But that being said, that attorney was really smart for filing the Lis Pendens. And nothing can happen on that property until that Lis Pendens is released.
So this goes against the homeowner's name?
It attaches actually the property itself. Okay, so it's very important that the Lis Pendens must have the address and the proper like parcel number for the property, and you want to list all interested parties so that everybody's on notice. Very important that you have that information in there.
Wow, so this is like a loan, almost like this is a lien against the property then.
It's not a lien, but it's notice that the title is in question.
Title is in question.
Yeah.
This is a memorandum. I don't know if that's. I mean, that's
no right. Memorandum is much more informal. It's just recording a document in connection with the sale, right? The purchase or sale. Whereas the Lis Pendens is really connected more to the ownership interest in the title to the property, the deed.
Nice. I would think the Lis Pendens is a little more powerful than
it is. It is, and it's also there's actually legal consequence to messing around with it. Yeah, but so you can use. I did some research yesterday after we were talking about it on someone's deal. Though you can use Lis Pendens on just a contract. Yeah, you can. The law does allow that.
So we get our sellers being funny. Go ahead.
Yeah, you can file the Lis Pendens, but you're basically filing that with the court action. So you're taking that extra step to file the breach of contract claim. Okay, so there's a little bit more money involved. You're doing filing fees now in the courthouse.
How much?
And you're required. So it could be anywhere, depending on $200 to $300. It depends on the county or the jurisdiction. But that's typically it's a few $100s, and you have to do proper service. Whereas the memorandum might be $20-25 to file the contract. This is going to cost you, anywhere from $200 to $300 plus service, and then you have to appear in court and answer on it. So it's usually I would say you have to really want this deal to go through to take the time to file the Lis Pendens.
But the good thing about it is we do not need Roundup family. We do not need the seller's signature to file the Lis Pendens, which is so powerful to me.
Yes, absolutely.
How many times have I seen where my clients come up, Chris, they've already signed the contract, didn't get the memorandum. Now the seller's backed out and they need to take another step. So I'm going to start implementing this. Jessica, when should we not do this? Is being the mom and attorney Jessica she was saying that this is a tool that we may not want to implement on every seller that backs out of a deal. Right.
Absolutely. So I think you have to really, it depends on the kind of business you're running, right? And I'm not passing judgment on anybody, but at the end of the day, you have to evaluate how hard am I going to go after somebody on this contract? And we were talking about, look, if this is purely a business decision where the guy's, the seller actually just trying to make more money on the deal and screw you over, or, basically they're trying to do something underhanded, then yeah, you may really want to fight because you were going to make profit on this deal and you're going to protect your interest. The flip side to that is, maybe in between the time somebody signed that contract and the time, you were going to get ready to close, they had a death in the family, or they've gone into bankruptcy, or that job they thought they were getting is not going to go through, or their family member was diagnosed with cancer. And now, there's things that happen to people in real life, a divorce, a death, these things. Like, do you really want to, basically force these people to sell the house so you can make profit? So, that's a very personal decision. And, on a case-by-case basis, you should evaluate, do I really want to go to court over this? That's really should always be how much money am I going to spend in a court proceeding to win? Is it worth it in this particular case? And there are going to be cases when it is. Absolutely. You're going to want to go all out, but not every case is going to be like that.
Gotcha. I had a question, Jay, about time frame. I know around here, the courts move like molasses.
Yes.
So when we file this Lis Pendens, is that going to be indicative of the same thing in this process?
It's going to be, well, yeah, the court system is very slow. And so, like, for example, the partition action that we started was over a year ago. It's been going on. It's still not resolved. And so that property is tied up for well over a year. And we're not even at the appraisal and sale part yet.
So it sounds like, based on what you're telling me, this could just be a good bargaining tool to get some dialogue going between us and the
Yes, it's a great tool to start conversation, because there's no you can always negotiate after the Lis Pendens is filed. You can always try and resolve it. And if you come to an agreement, you just basically rescind. You ask that it be dismissed, whatever the procedure in your court is. Withdrawn, vacated, whatever.
Is that a document we file under this, like the release of memorandum?
Yes, it would be like if you're in court, you're going to have a stipulation of settlement filed with the court, and then you're going to ask the judge to basically release the Lis Pendens.
Gotcha. That's a document they would have in that pile, no doubt. In order to go to closing, it would have to exist somewhere.
Exactly. Right. There's a release, basically.
Gotcha.
Yeah, and it's going to be signed off by the court. Yeah, and that's the difference is once you file the Lis Pendens, you're involving the court system. So you need permission, just like you need to, to get out of it. You can't just,
I love it.
Go on without addressing it.
Well, as we talked yesterday, Jay, I don't want to sock it to people. I just want to listen. Don't disappear on your board.
Yes, and I agree. That's it. Just answer the phone, right? You don't just ghost somebody that you've now entered into a deal with. But what I've learned, and I'm sure you've seen it, is some people are just not equipped with communication skills.
Yeah.
And when they're put in a stressful situation, they'd rather just ignore it than deal with it. And so if they're not capable, then you force them by having these documents filed. Yeah, especially if it's a big money deal, and it's different. Every deal is different. Yeah. But listen, I do the same thing in my law practice. Look, I've put work into stuff. I've taken money, and circumstances change. Mm-hmm. And I've definitely, sometimes you're going to give money back to people. That's the right thing to do. No matter what your business is, whether you're making cupcakes, selling houses, attorney, it's important to have integrity in your business.
It is. Oh man.
But that doesn't mean we should be taken advantage of,
Well, everybody thinks we're just the greedy investors, and we could miss a deal or two. You've made enough money. I've had the judge tell me, you made enough money.
That's terrible.
I was in court with, actually he told my mentor, I was in court with him, and he had got a $6,000 down payment from somebody. And the tenant didn't pay rent for 3 months. And the judge said, you know what, you've made enough money. We're just going to dismiss this whole thing.
Yeah, that's terrible.
You never know what the judge is going to say. I'm sure you have stories for the rest of the day on.
Oh, yeah.
All right, class. Is there anything else, Jay?
No, let's take some questions. See if anybody's that's what I would say is, have you been burned? What is an example so that how long into your business did you start using the memorandum of contract and things like that? How many years before you started using them?
I started using them. I started it in 2004. I didn't have this bad experience until about 2007, but I was just doing wholesaling back then. I didn't know what I was doing.
Yeah.
I get the contract, then sell the contract. But my only bread and butter was making sure if my seller didn't show up, then I was done. I got this buyer on the hook, and then it kept happening. I think I lost about 8 or 9, and I'm like, you know what? got to be a way to make sure these people are going to do what they say, and then
Yeah.
coming out. So finally figured it out. I don't know what it is. It's something about, I don't know if it's my personality. It's like, he'll be okay. He'll get over. Because a lot of investors that I know, people have said I've never had a seller back out of a contract. It seems like it's foreign to some people.
Yeah. I think it's in the traditional home buying situation, you don't see it that much. When you're in the subject to and the wholesale and you're dealing with like a volume business, you're going to see it more often. It's just statistics. If you're doing 20 deals a month, you're going to see it more often than if you're doing, one deal a month or a year.
Yeah. Yeah, and for me, even with the creative stuff, I'm like, I never forget I was teaching class, and I would always ask the class, when your seller doesn't show up, the general attitude is, well, you win some and you lose some. I'm like, no, I don't want to think like that. I want to make
No. Right. No way.
All right. Round up family, what questions do you have for attorney Jessica Segal on this beautiful Friday afternoon regarding Lis Pendens? Because I didn't even know too much about Lis Pendens, Jessica. We've been talking about it, but now that I know, I'm like, so I can recommend to my coaching clients, if they don't get the memorandum, which I'm going to whack them for not doing, now we can do the Lis Pendens after that.
Yes. Yes. Yeah. Oh, and one of the questions that we were talking about yesterday was also, what do you do if the seller, after the contract is signed, sends you an email saying, hey, listen, my circumstances changed, I need out, right? And it was like 24 hours later, and he filed bankruptcy, right? Because that's real life. And so one of the things that I was looking at there, for real estate, once the contract is signed, you're bound. After that, you have to come to some sort of negotiated resolution. Once you sign it, you're responsible.
Okay.
The 3-day rescind period that some people talk about, myself included, I had to really clarify that. That 3-day rescind period applies to federal, it's mandated by the federal government for financing. So for banks and loans and those types of documents. If you sign a financing statement, you have 3 days to rescind that agreement. But that does not apply to the traditional purchase and sale contracts for houses. Once you sign, you sign.
I love that, Jay. My thing is, and maybe it just come from being a mature real estate guy or businessman. Don't sign the paper if you don't know. Just think about it.
Yeah, absolutely.
By the time, I don't know. How about you, Jay? Do you sign stuff and do you regret? I mean, does it happen to you often?
No, I'm very conservative, so I really think things through, which honestly is why I've lost out on a lot of deals, because I was thinking about it too long. And honestly, I feel like, that's what my comfort zone. I think if you get to a point where you've got more cash on hand to make deals, you're not going to be as worried about it, I guess. But
my thing is think it through, make sure it's right, and then sign the paperwork.
Yes, make sure you really want it. Make sure the terms are what you want.
Yeah.
Yep.
That way you don't got to be going back.
Right. There's so many deals out there. If that wasn't the right one, you'll find another one. So make sure when you sign it, you really want it.
Daniel, he wants to know about can wholesalers do this? Yeah, I was just talking about that.
Yes.
Daniel asks, is there a list of cases that you could use to show the buyer what the repercussions are of backing out of the contract, Jessica?
I don't have a list of cases, no, unfortunately. But I mean, the ramifications for the buyer backing out it should be in your contract. There's typically, you're going to lose your deposit typically. But the contract should spell out what is the penalty for the buyer backing out.
Yeah. I know all.
And that's the most common one, is losing your deposit. That's why I tell most people, try and put down as little as possible in case you can't close for any reason.
If you can, yeah, we had to put up $1,000 yesterday. Sometimes I have to put up 10%. If you're buying from a bank, you just never know. And yes, the contract we use, Jay, it has the language, earnest money should deposit shall be the sole remedy.
Yes,
Sole remedy.
yes.
Not to say that some powerful attorney and judge would try to get over that.
But yeah, traditionally that is the remedy.
Yeah. Daniel has another one. Hey, Daniel, how do we, he's asking, how do we present this to the seller when you're doing the deal? How do we present the memorandum?
I mean, I like the way you call it, the deal insurance, basically. If you explain to them, this is just my insurance that this deal is going to go through. And, somebody who's legitimate and knows that they're going to sell you this property should have no problem signing it.
Yeah.
Most attorneys are going to know what it is. And if somebody really doesn't want to sign it, that's sort of a red flag. And then you can always do the Lis Pendens.
That's right. Well, Daniel, I just to answer your question, I just say, hey, here's another document we need you to sign.
That's what I was just going to say. You just present it with all the other papers.
I'm like, frankly, I tell them, listen, this document says you are who you are, and I am who I am, or that I'm a trustee, because you have to have it notarized. So anyone can sign a purchase and sale agreement. It could be a brother, or aunt, cousin, you don't even know. So when you give them that memorandum and it's got a notary on it, literally your signature is who you are. I didn't know who the heck you are.
Yeah. No, that's a great way of explaining it.
Yeah.
Especially if you're doing these deals without attorneys.
Yeah, title company. Yeah, that's true. But down here, we don't need we can do a title company. And you just don't know. You don't know who's signing the paperwork. Shit. I've had all type of stuff. Daniel, how often do sellers back out? I would say, shit, Daniel, I don't know, man. 1 out of 25. I mean, it all depends. I don't think there's a set number. Jessica, Daniel wants to know when we file the Lis Pendens, does that start the process? The Lis Pendens, does it start the process at that time, or do you have to wait till it reaches the judge to cloud the title?
I mean, I think it's as soon as it's recorded, honestly, by the clerk there. But you have to show proper service on the parties. So you're going to have to provide affidavits of service to show. So you have to make sure that you file the documents properly, you have proper service before the court will record it.
Nice. Ultimate Bargains. He is, oh my goodness. Can you summarize the doctrine of equitable conversation? Oh my, as it applies to a bilateral purchase contract and unilateral option contracts. But this guy is he's a super expert out there. He can't get him to come on yet though. Jay, you wanted to tackle that one?
I don't even understand the question, to be honest.
Yeah. Ultimate Bargains, you might have to dumb that one down for me. I'm like, I don't know. Okay. If we have no more questions coming in, Jay, final thoughts on the memorandum versus the Lis Pendens. It's not list pendants, it's Lis.
Yeah. Again, fantastic tools to have in the toolkit. When you know better, you do better, right? We're always saying. So now you know they exist. It's so inexpensive to do the memorandum. Always try and get your seller to sign it when you're doing your contract and just file it. That's your deal insurance. It's fantastic. Lis Pendens, for me, I think is an indication of a more serious approach, because you don't want to just be taking up court resources, honestly, unless you're prepared to file that lawsuit. So, use the Lis Pendens if you are serious about wanting to negotiate this deal. Yes, it's going to cost you a lot more too. So how much are you willing to invest in this?
Mm-hmm. I wish I would have had this tool. Anyway, I've been trying to figure out how to file Lis Pendens for the last few years, but now I finally got it. Hanging out with Jessica. C-Class is all about who you hang around. All about who you hang around.
Absolutely. Yeah, it's great. It's a great tool, and I'm always happy to answer questions.
Okay,
if
class.
they come up.
Thanks for hanging out with Jessica and I. Don't forget to subscribe to, was it Jessica and me? I don't know. Don't forget to subscribe to my channel and check out Jessica's channel as well. We'll see you back here for Attorney Time next Friday and possibly tonight for some very, very quick training. Jessica, thank you so much for your time.
Have a good weekend, everybody. Take care.
Bye.
Bye-bye.